Letitia George, Office of the Public Defender.
So it is as hot as the Sahara Desert outside in the hallway, and in this courtroom is pretty hot, and it's as cold as the Arctic in my office. That means you all may see me sniffling or sneezing, but it's not that I have a cold. I really do not. It's just the environmental stuff. The changing of going from cold to hot to cold all the time is ridiculous. It really is cold in the office and then hot in the hallway and hot in the courtroom, and I don't understand that. It's the same building, same floor. So I don't know how the temperature can be that different. Recalling Kamari Lucas. As to Mr. Lucas, case number 2023 MM 4734AO. The defendant is a juvenile, charged as a juvenile, and this matter is set for a detention hearing on July 10th at the juvenile courthouse in front of Judge Whitehead. I don't have the time, I just know I think they're all set at, yeah, yes.
And Your Honor, if I
Yes, ma'am.
could say something else.
Yes, ma'am.
Earlier, I just wanted the record to be.
Yes, ma'am.
I just wanted the record to be clear. I know earlier you revoked the bond on his other felony case based upon the new direct file case.
That's right.
That case was an event that occurred before the case that he was on bond. It just took them a while to direct file it. I did verify that with the Juvenile Bureau, just confirm. So that case.
Then that means that you all should not have provided that information to me, because that case had no bearing since it happened before this case. So somebody had to give me that, but I mean, I'm going to address that again right now. As my notes reflect, that would have been 2023 CF 3274AO, is that correct?
Yes, Your Honor.
Madam Clerk, I'm gonna have to address his other case. The court this morning, I revoked the bond, but with the additional information that that case actually occurred prior to the case that the defendant was scheduled for IA this morning, the court is vacating the order, revoking the bond. Whatever bond was previously ordered remains. If I sign that order, I need to vacate it. And as the defendant was charged with that offense before before the case that was scheduled for today. It's probably better to go by case numbers. What's the case number for today's case? Remember, I didn't do this from the affidavit, I did it from the face sheet. Somebody give me that case number, please.
The case number for today is 23 CF 8585.
8585AO, all right. The bonds that I ordered on 2023 CF 8585AO, they will remain, but the revocation of the bond and no bond status on 2023 CF 3274AO is vacated and set aside. The bonds and the conditions of bond previously imposed will remain in effect. I think we all got that now. And now recalling.
Your Honor, I'm sorry.
Yes,
One
ma'am.
more thing. I did talk to him about getting the child transferred for the misdemeanor to juvenile.
That's handled already.
Okay.
That's already set. That's set for a hearing, for a detention hearing on the 10th, July 10th. That's handled. So, so all the court minutes need to reflect is that Judge Whitehead is setting that case for a detention hearing on July 10th. And he'll make all the arrangements to have the child brought over. Okay. And I didn't set it, so Judge Whitehead is setting it. Just put Judge Whitehead is setting for a detention hearing on July 10th. Now, recalling Michael Cintron Rodriguez, and I re-reviewed this matter during it wasn't a break, I worked the whole time, but I re-reviewed this matter, and based on everything I see, The defense attorney appears that she's correct, that probation was revoked and terminated. However, if you all, meaning state and defense, have had a chance to re-review it and have any additional information to provide me, please do so at this time before I release the defendant.
Defense has no additional information, Your Honor.
I have no additional information, Your Honor.
All right, as to case number 2021 CF 14555AO, the defendant's probation was revoked and terminated, and he's released.
You released it, all right, so put all
Yes, I'm releasing the defendant on recognizance. That's fine.
report, probation was revoked and previously revoked. Yeah. What was the rating?
Spanish interpreter?
Good afternoon. This is Deo Rodriguez, certified Spanish interpreter. I have not been previously sworn.
Raise your right hand. Do you solemnly swear to translate from Spanish to English, from English to Spanish in the testimony given today?
Yes, I do.
Thank you. This is Judge Allen, and we have several cases. The first case is Jose Manuel Goico Torres, 2023 MM 4738AO. Is there an offer, and does he wish to accept it, counsel?
Yes, Your Honor. The offer is an adjudication of guilt, credit, time served, and no return to 4780 West Colonial Drive.
How much time served? Is it 2 days?
Miércoles.
Defendant entering a plea of guilty or no contest?
No contest, Your Honor.
Mr. Goico Torres, is this your signature at the bottom of this plea form?
Sí.
Yes.
And did you read the plea form before you signed it?
Sí.
Yes.
Are you under the influence of any alcohol, drugs, or medicine today?
No.
Do you understand that a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Sí, señor.
Yes, ma'am.
I find that there is a sufficient factual basis to accept your plea, and you are alert, you are intelligent. The court adjudicates you guilty, orders 2 days in jail with credit for 2 days' time served, and further ordering you to not return to 4780 West Colonial Drive. Further, I am ordering all mandatory court costs to be paid within 365 days of release. I'm ordering your release as to this charge, but if you have other cases pending, you may need to resolve them before getting out of jail. Do you have any questions?
No.
No.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you.
Gracias.
Thank you.
The next case is Gerardo Ruben Ramirez Correa. As to Mr. Correa, case number is 2021 CT 4489AO and 2020 CT 604AO. Sir, you have 2 cases for failure to appear. Bond will stay at no bond on both cases. I've appointed the public defender to represent you. You understand, sir?
Sí.
Thank you, sir.
Yes.
Your Honor, he also has an immigration.
Sir, let me inform you that you also have an immigration hold. Thank you.
Okay.
Okay. Next case is Josue Espinoza Lopez, case number 2023 CF 9000 AO. Are you Mr. Josue Espinoza?
Yes.
Mr. Espinoza, the court finds probable cause for possession of cocaine. Bond stays at $1,000. Possession of paraphernalia, you're released on your recognizance. Resisting an officer without violence, bond is set to $100. The court takes no action on your out on bond matter. And I've appointed the public defender to represent you. Do you understand, sir?
¿Tengo fianza? No. ¿Tengo fianza?
So do I have a bond?
Yes, sir.
Okay.
Thank you, sir.
Okay.
The next case is Yuri Jimenez, 2021 CF 12559 G. Oh, G as in gamma. Sir, you were picked up on a capias and bond will stay at no bond on all counts. Thank you, sir. You understand?
No tengo fianza. No tengo, no entendí, no.
And sir, one other thing, I have appointed the public defender to represent you on your case. Thank you, sir.
No entendí, no.
I didn't understand.
All right. You were picked up on a capias, a bench warrant, a warrant, and bond will stay at no bond on all counts. I have appointed a lawyer to represent you from the public defender's office. Thank you, sir.
Okay, no. Okay.
Thank you, sir. Is the next case for the Spanish interpreter or the Creole? Franco Miranda. Okay. Franco Miranda refused. Mr. Interpreter, since Franco Miranda refused and he's not present, thank you, you're excused. We appreciate your help.
Thank you very much, Your Honor. Have a great day.
Okay, you too. As to Miranda, as to the escape charge, the court finds probable cause and bond is set at $4,000. As to armed burglary of the other case, armed burglary of a dwelling with a firearm, bond stays at no bond. Grand theft first degree of 100,000 or more, bond is set at 10,000. Grand theft third degree of a firearm, bond is set at 1,000. Grand theft third degree of a firearm, bond is set at 500. Grand theft third degree of a firearm, bond is set at 100. The defendant is ordered to possess no weapons, no firearms. Surrender any weapon or firearm to law enforcement within 24 hours of release. No contact with the victim, and no return to where this incident occurred.
Your Honor, he also has an immigration hold for the record.
And the court minutes to reflect defendant does have an immigration hold. Thank you. Maximilian Claver.
Let me get the Creole, he's for the Creole.
All right. Is the microphone kind of angled towards Mr. Claver so he can hear? I mean, we can hear? Mr. Claver,
Yes, Your Honor.
thank you.
I think he picked up Jess. Interpreter.
Thank you. Mr. Interpreter, this is Judge Allen. Can you hear me?
Hello?
Hi, this is Judge Allen. Can you hear me?
Yes, Your Honor.
And can you
Yes, I
tell
can
us
hear.
what your name is, and we're gonna swear you in to interpret?
Yes, Your Honor. My name is Lord Jean-Jacques.
Okay, raise your right hand. Do you solemnly swear to translate from Creole to English, from English to Creole, in the testimony given today?
Yes, I do.
Thank
And now we're gonna swear in Mr. Claver.
you. Raise your right hand. Do you
Did
solemnly
you
swear,
lever mes doigts tout?
do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
Il dit, ou sermenté que déclaration pour le là, c'est la vérité, rien que la vérité, toute la vérité?
Yes, Your Honor, parce que je suis innocent.
Yes, Your Honor, because I'm innocent.
Sir, there are several things, you can take your hand down now. There are several things. First of all, I do find probable cause for 2 charges.
Il dit que ça gain plusieurs, gain 2-3 bagailles.
Aggravated,
Dit ouais que gain nécessité pour 2 accusations que vous faites contre vous-même.
for the charge of aggravated assault, I am ordering a bond of $2,500.
Il dit comme ça que pour accusation que ou t'es agressivement attaqué au monde, m'a mette une amende de $2,500.
And for the charge of trespass, I am ordering a bond of $100.
How much, Your Honor? I'm sorry, I didn't hear it.
Yes, sir. For the charge of trespass, I am ordering a bond of $100, sorry, 100.
100, ok, thank you, Your Honor. Il veut dire comme ça pour l'autre accusation que ou vin au côté pas supposé rentrer, ok? Et puis, moi mettez une amende de $100.
And I am ordering you to have no contact with the victim.
Et qu'on y a la vie, moi pas sur l'ordre pour pas aucun contact avec victime nan.
Merci, Your Honor, parce que je suis
I am ordering you to not return to where this incident occurred.
Et puis, le manteau tout, côté bail ça t'est fait là, pour pas tourner là.
I am ordering you to possess no weapons and possess no firearms.
Il dit comme ça que, et le finiment de tout, pour pas posséder, pas même mon couteau pour passer.
I am ordering you to
Allez voir pour ta
surrender.
gain, allez voir
One moment, sir. Sir, don't interrupt. Do not interrupt.
Dis-vous pas interrompre le mabdou ça.
I am ordering you to surrender all weapons or firearms to law enforcement within 24 hours of release.
Il dit comme ça que, et puis moi bon l'autre tout, quel que soit zam côté gain, revolver et plus pour le remettre yo, pour retourner à la police.
I am appointing a lawyer to represent you from the public defender's office.
Et puis le fini ma bon avocat pour représenter dans office et public là, avocat public là.
You have another case that you are out on bond on for criminal mischief.
Dis-vous qu'on l'autre cas encore. OK? Côté que ou dehors et c'est sous bond qu'au dehors.
I need to
Pour affaire criminelle.
find out from the state if that charge has been filed or not.
Et puis le film qu'on y a là m'a pour checker avec état pour me connaître si est enregistré accusation ça.
Ms. Shorter, could you confirm the status on the criminal mischief charge?
Yes, Your Honor, I'm going to review it right now. The criminal mischief in 2023 CF 4733 has not been filed on yet.
I will take no action on the criminal mischief charge.
Il dit comme ça que li pas ouais et il pas enregistré et pourquoi aucune action qui faite sous criminel et accusation criminelle malfaisance. malfaisance criminelle.
Finally, sir, I
Finalement,
would like for you to let me know if you understand everything that I have ordered.
finalement, m'a demandé est-ce qu'on comprenne
Tout
tout l'autre ça yo que m'ba ou.
Demande honneur seulement s'il te qu'à descendre bon pour moi, s'il vous plaît. Dis honneur ça, s'il vous plaît. Parce que je ne pas tout comme ça,
I,
s'il vous plaît.
I understand. I understand. The only favor I'm asking you, Your Honor, not really a favor, only thing that I'm asking you, if you could lower the amount of the bond because I don't have that kind of money presently.
No, the bond amounts will stay as I have ordered them.
Li di, non, bon yo, ok? Y a pou obligé rete jan kouwe, mwen mete yo.
Thank you, sir.
Dis le bon Dieu béni.
Merci.
Dis le bon Dieu béni.
Oh, thank you, Your Honor, and may God bless you.
You're welcome. God bless you too.
Li di ou mèm tou, de rien ou mèm tou, que bon Dieu béni ou.
Merci.
Okay, thank you.
Thank you.
That's it. That's it, Judge Winter.
Thank you, Mr. Interpreter.
It's a pleasure, Your Honor, and thank you for using our services.
You're
Have a great
welcome.
afternoon.
That's fine.
Thank you.
Mm-hmm. Thank you.
We left that one that you said, Sean, we left it in his spot, so we go to the next person.
Heather Leary?
Should I drop off the call,
Apologies for my
Your
hair.
Honor?
I had it in a bun.
Yes, Mr. Interpreter, you're excused. Thank you. Are you
Okay.
Heather Leary?
Yes, ma'am.
The court finds probable cause for escape. Bond is set at $4,000. And resisting an officer without violence, bond is set at $150. You are also charged with violation of pretrial release. Bond will stay at no bond as to that.
If you could please do a bond on that. I had a seizure the day of the appointment. It wasn't that I meant to miss the appointment. Like, there's hospital proof of the seizure. There's a person that witnessed the seizure. It wasn't like I was on the way to the appointment and
The Honorable Judge Petra Brownlee signed the no bond order, and I've appointed the public defender. They will need to file a motion and have it scheduled to be heard by Judge Brownlee. Thank you, ma'am.
All right, so I cannot get out because of that one, correct?
No, ma'am.
All right, thank you, Your Honor.
Shanice Buchanan, the court finds probable cause. Yes, ma'am.
This is verdict, Johnny in arraignment.
Okay. Oh, do I have the arraignment files? No one has handed me any arraignment files. All right, okay.
When we can address Kenneth Lee? He was on before. You guys go with a regular paperwork? Perfect. Thank you. Sounds good. Put it back in the list. Yeah, that was a mental health. Yeah. Thank you.
Oh, I see. All right, Mr. Johnny Clay Furtick? Is that who this gentleman is?
Yes, Your Honor.
All right, it does indicate that he is pro se, so no public defender has yet been appointed. Sir, you're here for an arraignment as to a charge of petty theft. And, have you spoken to him as a friend to the court, and does he wish to enter a plea?
Yes, Your Honor. The offer from the state was an adjudication of guilt, credit, time served. No return to 124 West Pine Street. There's also a cost of investigation in the amount of $173.70 to the Orlando Police Department. And he would like to accept the state's offer and enter a plea of no contest.
That's fine, but you're kind of detailed there. Does he have, an application for the public defender? Has he filled that out?
No, Your Honor.
Let me talk to him. Mr. Furtick, raise your right hand to be sworn in.
Do you solemnly swear to affirm the testimony shall give me the truth, the whole truth, and nothing but the truth?
Mr. Furtick, answer out loud. I need to hear you, okay? Sir, have you had a chance to read this plea form? Oh, you can put your hand down now. And did you have any questions about anything on the plea form?
No, I don't.
All right. You understand that by entering your plea, if you do decide you want to enter a plea today at your arraignment, that you're giving up all the rights on this plea form and this is going to resolve the case right now?
Yes, ma'am.
And are you wanting to do that without having a lawyer appointed to represent you, since you don't have a public defender at this point?
Yes.
Okay, all right. I'm gonna go ahead and go forward with it and make a note that the public defender just announced his desire to plea as a friend to the court. All right, do you understand that by entering a plea of guilty or no contest, sir, I may have already asked, but I'm gonna repeat it, that you're giving up all the rights on this form?
Yes.
Are you under the influence of any alcohol or drugs or medicine? Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes.
Oh, my goodness, I have to look this one up. Can you look that one up for me?
Do you,
And just
I
print
have
out-
the affidavit.
You have it? Okay, can I have it? Sir, there is a sufficient factual basis to accept your plea. You are alert, you are intelligent at this time. I will adjudicate you guilty. How much time, sir?
27.
Order 27 days in jail with credit for 27 days time served in order you to pay mandatory court costs within 365 days of your release. I am ordering your release as to this charge. However, if you have any other case pending that's holding you in jail, you may need to resolve it before you get out of jail. Finally, sir, I am ordering you not to return to 124 West Pine Street and to pay costs of investigation of $173.70 to Orlando Police. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Here you are, Ms. George, you can have that back. Okay, are there any other arraignments?
Nope, that was it.
Shanice Buchanan?
Yes, ma'am.
The court finds probable cause for misuse of 911, bond is set at $500, and assault on a law enforcement officer, bond is set at $100. Thank you, ma'am. Rodney Bullock? The court finds probable cause for trespass on property. Is there an offer that he's accepting?
There's an offer, Your Honor, however, he might qualify for pretrial diversion. Defense would ask for an ROR. He doesn't have any.
Any objection, State?
No.
Okay, now, this is a case that happened at the Orlando International Airport. And this case seemed just a little bit more involved than your normal run-of-the-mill trespass. So I don't know about the ROR.
the bond, please? I'm not too sure. I have to make a call.
You know, I ROR people a lot on trespass charges, and you're gonna hear that a lot. If people don't take pleas, I tend to ROR or reduce the bond. But this is one where I did already reduce it to $500 from the 1,000, but I'm not willing to ROR the defendant. I'll reduce the bond to $500, no return. Yes, ma'am.
Your Honor, in that case, we're just gonna resolve the case. The offers from the state was a withhold of adjudication.
I'm not gonna withhold. I'll adjudicate him guilty. Ma'am. Yes, ma'am.
I didn't see any convictions. I just saw arrest on his record, even from out of state, Your Honor.
I would adjudicate him guilty. That's the court's ruling.
Bond, yes. I'd love to do the bond. Thank you.
You're welcome. We'll do the bond.
All right. Bond is set at $500. You're ordered to not return to the location where this incident occurred.
Thank you so much.
You're welcome.
Freddie Cannon? Yes, ma'am. The court finds probable cause for battery. Bond is set at $500. You're ordered to have no contact with the victim, no return, possess no weapons, no firearms, and surrender any weapon or firearm to law enforcement within 24 hours of your release. Thank you, sir. Valencia Renee Garner.
Yes, hi, how are you?
Hi.
I'm not guilty.
Right. I do find probable cause for the charge, and I am going to set a bond of $250. And the court is not taking any action on the other two trespass cases that you're out on release on recognizance.
Yes, ma'am, but I didn't do it. I wasn't on Walmart's property.
That's why I set a bond, ma'am. I set a bond.
Bond, you should dismiss it. I'm not
Well,
understanding.
Once you file your motion to dismiss, the judge will read it and make a decision whether to dismiss it or not. I'm not the judge on the case.
Oh, okay.
Thank you. Jennifer Hooper. All right, the court finds probable cause for trespass on property after a warning.
Your Honor, she has no criminal history. Defense would ask for an ROR.
That's granted if the state has no objection. Ms. Shorter, are you having no objection to that? It does say she's been there multiple times and they're trying to keep her away from there. Ma'am, Please, I'm talking to the state, but I'll still ROR her with the condition that she not return unless the state has an objection.
I don't have an objection, Your Honor. I just ask no return to that location.
Ma'am, I'm gonna grant, the defense motion for release on recognizance, but you are ordered to not return to the location where this incident occurred. Kenneth Lee,
Mental health, Your Honor.
all right.
Defense a waiver, Your Honor.
Court finds probable cause, bond is set at $500, no return, no contact, possess no weapons, no firearms, surrender to the law enforcement within 24 hours of release. Mental health,
Was that Mr.
waived, defense waived.
Do not return.
Amber Lucas,
Your Honor.
sorry.
It's criminal mischief, first appearance detainer for Mr. Lee.
Mr. Lee has for another charge,
Yes, Your Honor.
and so that he's out on bond on?
Yes.
Was I aware of that? Is it attached?
Yeah.
Oh, yes, no action. No action on that. The court takes no action on the case that he's out on bond on. Thank you.
No weapons, no firearms.
Yes, ma'am, I did say no weapons, no firearms, and I said surrender weapons or firearms to law enforcement within 24 hours of release. Amber Lucas,
Ma'am.
the court finds probable cause for trespassing on property after a warning.
And, Your Honor, the offers and adjudication of guilt, credit time served, and no return to 601 North Orange Blossom Trail. Ms. Lucas would like to accept and enter plea of no contest.
Ms. Lucas, is this your signature at the bottom of this plea form?
Yes, ma'am.
I need the time, sir. Did you read this plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine?
Ma'am, I was trying to collect my belongings.
Are you under the influence right now
No, ma'am.
of any alcohol, drugs, or medicine?
Oh, no, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Correct. Yes, ma'am.
There is a sufficient factual basis to accept your plea. You are alert, you're intelligent. At this time, I'll adjudicate you guilty.
Yes, ma'am.
Order 2 days in jail with credit for 2 days' time served, and order you to not return to 601 North Orange Blossom Trail. Further, you must pay all court costs associated with this charge, and monies must be paid within 365 days of release. I am ordering your release as to this charge. If you have any other cases pending, then you must resolve them before you get out of jail. Any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you.
Thank you, Your Honor.
Felicia Rainey? The court finds probable cause for petty theft. Bond stays at $250. I'm ordering no contact with the victim, no return. Rafael Rodriguez?
Mental health, Your Honor.
Can we reset for tomorrow? There's an offer, Your Honor.
Yes, reset Rodriguez for 24 hours. John Anthony Sanchez. John Anthony Sanchez.
Yes.
The court finds probable cause on each count. As to count 1, petty theft of $100 or more, bond stays at $500. Count 2, petty theft of $100 or more, bond stays at $100. Count 3, petty theft of $100 or more, bond stays at $100. And count 4, petty theft of $100 or more, bond stays at $100. I'm ordering you to have no contact with the victim, no return. Anthony Santana.
Good afternoon, Your Honor.
Good afternoon. The court finds probable cause for your charge of battery. Bond is set at $500. You're ordered to have no contact with the victim and not to return to the location where this incident occurred. Possess no weapons, no firearms. Surrender any weapon or firearm to law enforcement within 24 hours of release. Thank you, sir.
Yes, ma'am. Thank you.
Corey Slaughter. The court finds
Your Honor.
probable cause.
I was just gonna say, I believe this should just be a simple petty theft, not a petty theft of 100 or more. I saw it was only $15 worth of items.
I found improbable cause, and the court would set bond at $250.
Mm-mm. So, Your Honor, you're finding petty theft of 100 or more? I was arguing there's PC, but only for a simple, not 100 or more. They charged him under the wrong statute.
Let me see that.
Because it was $15, they put petty theft of 100 or more.
Oh, it's, well, it looks like a petty theft of a merchant.
It's the,
I don't know, I don't see what you're talking about.
so, statute 812.014 2E is the petty theft taking of $100 or more.
This is somebody else, this is.
But this is a,
Sanchez before?
No, this is slaughter.
Corey Slaughter. It's petty theft of a merchant. What is this about
On mine,
transit?
it says petty theft. I was looking at the statute, petty theft of 100 or more.
What, I don't, there's
the
something
E-
about a transit.
I don't know why it comes out like that, Your Honor, but if you look at the statute 812.014 2E, the subsection 2E says that you stole something over of $100 or more.
Well, that clearly is not what's in the affidavit. State, is it possible that you all wanted to charge him under a different statute?
Your Honor, I just pulled the statute to review it. It is under 812.0142E. That subsection does say if the property stolen is valued at $100 or more, but less than $700. So at this time, most likely the state would only be filing a charge for a petty theft in the second degree, which would be under 3A, which would be the misdemeanor in second degree, since it is only $15.
812.0143A.
812.014 2, and then I go to, instead of subsection E.
Is there, so is this charge petty theft of a merchant, or is it petty theft of an amount greater than a certain amount, or?
It's greater than a certain amount. I think it's merchandise in that amount, because when I pulled up 812.014, that's the statute for just theft.
Okay.
And then under the subsection, it then goes into the different amounts.
All right, so what's the amount for, they put in the affidavit that it was $15. We need the statute so I can find probable cause under that particular statute.
It would be 812.014 subsection 3A.
All right, any objection, defense?
No, Your Honor.
All right, pursuant to Florida statutes 812.014, parentheses 3A, I do find probable cause for petty theft, and I'll set the bond at $150. No contact, no return. Zan McLean, Zatavius Watkins.
Defense will waive.
The court finds probable cause on all counts. Bond stays at 500, 100, and 100 respectively on all counts. No contact, no return, no weapons, no firearms. Surrender weapons or firearms to law enforcement within 24 hours of release. James Williams.
Sign here. That's you? Yes. Sign right here, Ms. Williams.
The court finds probable cause for trespassing.
And, Your Honor, oh crap. Do you happen to have the case number?
Yes, ma'am. 2023 MM180, A as in apple, E as in echo.
And the offer from the state to resolve the cases in adjudication of guilt, credit time served, no return to 8738 Pissa Drive. And he would like to accept the state's offer and enter plea of no contest.
Thank you, I need the time, sir.
Here you go.
Is this your signature here at the bottom of this plea form, sir?
Yes.
You read this plea form before you signed it?
Yes.
Are you under the influence of any alcohol or drugs or medication right now?
No, ma'am.
Do you understand that a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
There is a sufficient factual basis to accept your plea, and you are alert and intelligent. At this time, you're adjudicated guilty, ordered to serve a day in jail with credit for 1 day. Time served, you're ordered to pay all mandatory court costs within 365 days of release. I am ordering your release as to this charge. However, if you have any other case pending, you may need to resolve them before you get out of jail. You are further ordered to not return to 8738 PISA Drive, PISA Drive. Do you have any questions? No, ma'am. You have the right to appeal. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. Carmen Bradley Frankowski.
Yes, ma'am.
The court finds probable cause for luring or enticing a child. Bond is set at $500. You're ordered to have no contact with the victim and no contact with any minor children under the age of 18.
Yes, ma'am.
You're also no other conditions.
Yes, ma'am.
Actually, there is one other condition. State, was this done electronically or not? Should I do a no return provision is what I'm trying to.
Let me, because I didn't have it.
I did read this affidavit. I read it, but I just don't remember. I didn't write a note as to whether this was a physical or was it done electronically.
I'm gonna pull it up really quick. Physically.
You're ordered to not to return to the location where this incident occurred.
Yes, ma'am.
Phillips Jeremy. The court finds probable cause for possession of paraphernalia and will order you to be released on recognizance as to that charge. You also have a charge of failure to appear for which bond will stay at $500.
Is there any, is there,
Thank you.
can I say anything, please?
Ms. George?
Yes, Your Honor, he's asking if he could resolve the case. State's not making an offer.
I have 34 days in on
I'm
a
gonna double
petty
check.
theft.
Is it enhanced? I just want to make, because I was gonna ask for an offer.
I'll plead guilty to time served.
Is the state making an offer or not?
I'm just gonna see if the trial attorney has an offer already in the file for him.
If there's not an offer already in the file and you're not able to make an offer,
I
when
don't
is-
make offers without full criminal history on petty thefts.
I don't have it.
So I'll
I understand, we all have our policies and procedures. What I was going to say is if there is not an offer and you're not able to make an offer, sir, I wanted to ask the clerk when your next court date is. Madam Clerk, when will this next court date be? For the failure to appear.
There is an offer from the trial ASA. It would be adjudication, 3 months supervised probation, impulse control, 30 hours community service, cost of investigation, cost of prosecution, and restitution if all items were not recovered.
The court's not gonna impose that. So, sir, you're gonna have another court date, and on or before that court date, your lawyer needs to make contact with you and schedule you for a plea if the lawyer is able to discuss a plea of time served or something that's acceptable to you. But the plea offer that just was read into the record, I wouldn't sentence you to that.
Ma'am,
So I have to sit in jail for another month?
I don't know. I really don't know, sir.
I'll just see if I can pull up
Yeah, I'm
some
gonna lose
priors.
everything again.
Sir,
I can't afford, I
I'm
can't
sorry,
afford
sir.
everything. Like,
I-
wait, like,
Your Honor?
Sir, listen to me. Everybody has a story, but I don't have the ability to hear every single person's full story. Sir, you can go ahead, be excused. I was just trying to talk to you, but I don't like people talking over me, sir. Joshua Fleming.
Bonded, Your Honor.
Previously bonded per jail staff. Onaya Garland.
Yes, ma'am.
The court finds probable cause for camping. Bond stays at $250 and state misdemeanors. Bond stays at $100.
There's actually an offer to resolve both with a withhold of adjudication, credit time served, no return. I believe it was to West Concord Street in Garland Walk. I believe it's like a railroad, if I'm not mistaken. It didn't have an exact address. I know you said no return, but I didn't see an exact.
The address would be around the intersection of West Concord Street and Gertrude's Walk.
Gertrude. Oh, I spelled that wrong.
West Concord Street and Garland, or
It's
West Concord
it is
Street and
Gertrude.
Gertrude?
Gertrude's Walk,
sorry.
Orlando Urban Trail.
Gertrude. Sorry, Your Honor, I couldn't read my.
Gertrude?
Yep, it looks like it's
Gertrude's Walk.
G-E-R.
Gertrudes. It's also known as Orlando Urban Trail.
How much time, sir? Ma'am, is this your signature at the bottom of this plea form?
The one you just signed.
Ms. Garland, is this your plea signature?
Yes, ma'am.
Did you read the plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol, medicine, or drugs at this time?
No, ma'am.
Do you understand that by entering a plea of guilty or no contest, you're giving up the rights on the plea form?
Yes, ma'am.
Do you understand that conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
There is a sufficient factual basis to accept your plea. You're alert, you're intelligent. You are withhold adjudication of guilt, order 2 days with credit for 2 days time served, concurrent on count 1 and count 2. You are ordered to not return to the intersection of West Concord Street and Gertrude's Walk as a condition of your release. Further, or your sentence, I should say. Further, you must also pay all mandatory court costs within 365 days of your release. Do you have any questions?
No, ma'am.
Ma'am, one other thing, if you have any other case holding you in jail, then you may need to resolve that case before getting out of jail. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days. Thank you. You're excused.
Your Honor, she has an out on bond.
No action on the out on bond case. Kristen James. The court finds probable cause for urinating or defecating in a public place. Bond stays at $250. You're ordered to not return to the location where this incident occurred.
Your Honor,
Mm-hmm.
he wasn't, I don't believe he was brought up at the time. I don't think he was brought up at the time, but there is actually an offer to resolve the case with an adjudication of guilt, credit time served, and no return.
Have him step back and read that plea form, and if he reads it and he wants to take it, then I'll.
I'm a girl.
Me too.
I'm sorry.
Guess what? I'm a girl too, but I get called sir all the time, and you know what I do? I just grin and bear it.
Just take this.
I get called sir all the time. I take it as a badge of honor. That means some people don't know who I am. All right, Kristen James, you can step back and read that, Miss Kristen James, as we know you're a girl. You can step back and read that, and I'm still gonna take your case, but I'm gonna take someone else's case first, okay? All right. No, I get called sir all the time, I don't care. I don't know, is my mustache growing, or is it because I have a deep voice? Or is it because everybody thinks a judge has to be a man? So they call me sir. I don't care.
And, Your Honor, I had a PC challenge.
As to Jerome Mills, go ahead.
I would argue no PC based on the affidavit. There's no indication that the vehicle was stopped in accordance to a traffic control device. Defense would argue no PC.
It says it was stationary.
I understand, Your Honor.
What says the state? I mean, I plan on ROR in them anyway.
Okay, that's what I was gonna ask for.
So I found probable cause, but I'm releasing the defendant on recognizance. I also am taking no action on the other case he's on release on.
Thank you, Your Honor.
No return to the location where this incident occurred as a condition of release. Thank you, sir. Jacqueline Washington. Court finds probable cause for possession of alcohol and possession of paraphernalia. Well, the state misdemeanors charge, which essentially is a possession of paraphernalia.
The offer from the state, Your Honor, is an adjudication of guilt, credit time served.
Okay,
And court costs, and Ms. Washington would like to accept and enter a plea of no contest.
that's fine. How much time served does Ms. Washington have? All right, that's fine. Ms. Washington, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And hand it back to me when you get it. Did you read this plea form before you signed it? Yes or no?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medication? Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen? If you're not a citizen of the United States of America, do you understand that you can be deported back to your country of origin based on a conviction on this case?
You gotta say
Yes,
it loud.
ma'am.
You understand that?
Yes, ma'am.
All right. There is a sufficient factual basis to accept your plea. I will accept your plea. I need the affidavit back. I'll adjudicate you guilty as to both count 1 and count 2. Order 2 days in jail with credit for 2 days' time served, and order you to pay mandatory court costs within 365 days of your release. I am ordering your release as to this charge right now. However, if you have any other case pending or holding you in jail, then you may need to resolve that case before you get out of jail. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. You may exit. And has the other young lady been able to read the plea form?
Yes, Your Honor.
All right.
There you go. And the offer, Your Honor, from the state is an adjudication of guilt, credit, time served. And she would like to accept the state's offer and
I
enter a
think
plea
I
of no
already gave you that affidavit. This is Miss Kristen James.
Yes.
2 days. Is this your signature at the bottom of this plea form, Kristen James?
Yes.
Did you read the plea form before you signed it?
Yes, I did.
Are you under the influence of any alcohol or drugs or medicine?
No.
Do you understand a conviction on your case will subject you to deportation if you are not a U.S. citizen?
Yes.
All right, there is a sufficient factual basis to accept your plea, and you are alert, you are intelligent. I will adjudicate you guilty, sentence you to 2 days in jail with credit for 2 days' time served, and order you not to return to where this incident occurred. I further am ordering you to pay mandatory court costs within 365 days of your release. If you have any other case holding you in jail, you may need to resolve it before you are released. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. You're excused. Lonnie Chandrian Watkins. Mr. Watkins, I find probable cause for disorderly conduct and order you be released on your recognizance. The court takes no action on the other out on bond matter. Thank you. Adon Bayona Fernando,
Bonded, Your Honor.
previously bonded per the jail staff. Lil Wayne Terrence McZeeke. You were picked up for failure to appear and bond will stay at $1,000 as to that charge. Thank you. Yulia Milovidova,
Bonded, Your Honor.
bonded per jail staff. Francisco Parilla, you were picked up for failure to appear, bond will stay at $500. Thank you. Manuel de Jesus Perez Javier,
Bonded, Your Honor.
bonded per jail staff. Sebastian Ainsley Vasquez,
Bonded, Your Honor.
bonded per jail staff. McCombie Johnny Brown,
Yes, Your Honor.
the court finds probable cause for possession of cocaine. Bond stays at $1,000 and probable cause for trespass, for which the court will ROR, release you on recognizance. You are ordered to not return to the location where this incident occurred and have no contact with the victim.
Yes, Your Honor.
Bo Chin, thank you. The court finds probable cause for possession of 3,4-methylene methamphetamine ecstasy. Bond is set at $1,000.
It's not mine. Can I say something?
No, I don't believe you can. Bond will stay at $1,000.
Your Honor.
Yes.
I don't know what they do that at. It's not even.
Mr. Bochin, you do have another case where you are out on ROR. I want to know, have that case been filed on yet? 2023 CF 5980AO. If an information has been filed, please inform of which counts were filed.
Okay. 5980, that case has not been filed.
All right, no action on the out on bond matter. Thank you, sir.
Hey, can I ask you? Can I talk about?
No, sir.
This police painted charges on me like I didn't even have the drug on me.
Sir, I know that that's what you're saying. You need to discuss that with your lawyer. Anthony Clark. The court finds probable cause for aggravated assault with a deadly weapon. Bond will stay at $2,500. You're ordered to have no contact and no return. Possess no weapons, no firearms. Surrender weapons or firearms to law enforcement within 24 hours of release. Thank you, sir.
Your Honor.
Yes, sir.
Mr. Clark has a, just says conditional release of the active program. Doesn't have a case number or anything. Not sure why they put that in there, to tell you the truth.
It appears that he was in a group home for people who are released from incarceration. I don't know that the judge that sentenced him on the original charge has violated him on any of his conditions of release. I don't have any documentation of that, so state, unless you are aware of that, then I don't intend to address it at this time.
We're just gonna see if there's any notes.
They didn't put any notes in my system either, Your Honor. Apologize. Other than conditional release.
I can reset it for 24 hours to give the state additional time to provide the court with any additional information, or just take no action since there's no other case that I've been made aware of.
I don't have any additional information, Your Honor, on it.
All right, and no other, the bond of 2,500, no contact, no return, surrender any weapons and possess no weapons or firearms. That's the order. Thank you. Thank you, sir. Roger Clark. The court finds probable cause for possession of possession of 3,4-methylene MDMA ecstasy, and bond will stay at $1,000. You're ordered to possess and consume no drugs or alcohol as a condition of release. Malik Shaquan Corbett. Malik.
Your Honor,
Corbett.
excuse me, on Mr. Clark, there's two cases.
Mr. Clark.
There's 23 CF 1432.
Mr. Clark, yes. Yeah. Mr. Clark. Mr. Clark, you had a second case for possession of cocaine, and I do find probable cause on that too, based on your PC warrant. Bond will stay at $1,000. Thank you.
Your Honor, could I say something concerning this on possession?
No, sir.
Okay.
Thank you.
Thank you. Have a nice day.
You do the same. Malik Corbett. The court finds, well, you were picked up actually for failure to appear, and bond will stay at $5,000 on count 1 and $300 on count 2 for your failure to appear. Thank you. Sir. Eugenio Cuevas.
Bonded, Your Honor.
Bonded per jail staff. Reginald Curtin. The court finds probable cause for robbery with a weapon, armed, and bond stays, that was based on a PC warrant, sir. You picked up based on a PC warrant, bond stays at $10,000. And as to count 2, aggravated assault with the weapon, bond stays at $2,500. You're ordered to have no contact with the victim, no return to the scene, and surrender any weapons or firearms and possess no weapons or firearms as a condition of any bond. Thank you. Christy Damaris Thebo.
We skip over her, Your Honor. She was arrested.
I'll pass that case. Lamont LaTroy Flowers. The court. You were picked up on a capias, and bond will stay at $5,000 count 1, $150 count 2, and $2,500 count 3. You were also picked up on a failure to appear. Bond stays at $1,000. You're ordered to have no contact with the defendant, co-defendants, or victims, and not to return to the location where this incident occurred as to the burglary charge. Thank you.
Can I ask a question, ma'am? I don't know, like, the defendant, like, or any, I don't know what the charges against me are. I don't know who the person is.
That's why a lawyer has been appointed to represent you, and then you'll have a consultation with the lawyer. At that time, you do need to discuss with the lawyer all the facts of the case that you are aware of, and the lawyer will tell you all the facts that the state has provided to them. Thank you. Kelly Gibbs.
Medical, Your Honor.
Defense waived.
Defense waives. The defendant was picked up on a PC warrant, and bond stays at $7,500 on count 1, sale of fentanyl, count 2, sale of methamphetamine, $150, possession of fentanyl, count 3, $150, possession of methamphetamine, count 4, $150. Further, the court, as to the possession of paraphernalia, will order release on recognizance. Thank you. Nicole Elizabeth Griffith. As to possession of cocaine, the court finds probable cause, bond stays at 1,000. Tampering with physical evidence, the court finds probable cause, bond stays at 150. And resisting an officer, the court finds probable cause, bond stays at 100.
Your Honor, is that Nicole Elizabeth Griffith? Because I have different charges.
Nicole Elizabeth Griffith. And then there is a second file of driving with a suspended or revoked license, and bond does stay at $500 as to that charge. As to the out on bond matter, here, it's the same, 6549, 6549. Pretrial release. I am going to revoke the pretrial release and order a bond of $500. No contact, no return. No weapons, no firearms. And surrender any weapons or firearms to law enforcement within 24 hours of release. Jonathan Guerra.
Bonded, Your Honor.
Jonathan Guerra bonded? He has a VOP with no bond. Let me see, Jonathan Guerra.
Yes, Your Honor, he bonded on his 2 charges, but the VOP is open. It's an out-of-county for willful flee and elude, and it is an open case he has.
How was it possible that he was released from jail knowing that there was some?
He's still here, Your Honor. They didn't release him, but
Oh, he's still in jail? Okay. Well,
he needed to be that probably should be addressed, the out-of-county
Yes,
reset,
there-
or brought up.
Yeah, he has to be.
Has to be seen.
Brought up.
Can we bring him up now? I mean, where is he located? I know the jail is big.
Hey, 11.
No, they're not.
Well, where is he?
He's like downstairs.
He's right downstairs? Yes, yeah, bring him on up. Otherwise, we will have to reset him for in the morning, so let's bring him up now. Okay. Okay. Recalling Christy Febo. Ma'am, the court finds probable cause for possession of drugs or a controlled substance without a prescription, and bond will stay at $1,000.
And Your Honor, Ms. Febo states she cannot afford a monetary bond. She's asking the court for an ROR.
State.
I would just ask for a bond. I'm gonna see if she has other cases.
I'm sorry, asking what?
I'm just looking to see if she has other cases. Your Honor, at this time, I'm not really sure of where the defendant lives. In Apopka?
State, I'm not as concerned about where the defendant lives as I am about the defendant's priors.
Your Honor, I don't see any
Mhm.
priors. I see an
Mhm.
old traffic case
Mhm.
and a case that was just closed in May with no information filed.
Mhm. What was the charge?
That case was a non-arrest for
Mhm.
DV battery.
Okay. You're not showing any convictions?
No, I'm just going through each one, all the felonies, just to see.
Mhm.
No info.
No dangerous felonies, no violent felonies, none of that?
Your Honor, I have her history if you'd like it.
Yes, sir.
1 felony, 2 misdemeanors, 5 failure to appear. His last failure to appear was on 3/23/22. Her conviction, last one, 1/8/21 for possession of cocaine. And she does have a dualist and giving false ID to Leo.
The court will allow the bond to remain at $1,000 at this time.
Nope. Take the paper.
Carl Lee Hill. Mr. Carl Lee. The court finds probable cause based on a PC warrant. Bond is set at $1,500 on the public order crimes, tampering with an electronic monitoring device, and $500 on the grand theft count. You're ordered to have no contact with the victim and no return to location where the grand theft occurred. Thank you. Jaquan Devon Ingram.
Pencil wave.
The defendant was picked up for failure to appear. Bond stays at $1,000. Nicole Jimenez. This person here refused. Jaquan Ingram. All right, Nicole Jimenez. You were picked up on a PC warrant for first-degree murder with a weapon. Bond will stay set at no bond. You are ordered to possess no firearms and no weapons and surrender any in your possession to law enforcement within 24 hours of release. The court revokes pretrial release on case number 2023 MM4024 AO and sets a bond of $500. Perry Lessam.
Defense will waive.
All right, defense waives its presence. Defendant was picked up on a PC warrant. Bond stays at $10,000 on count 1, 100 on count 2, and 100 on count 3. Thank you. Michael Lewis. Sir, you were picked up for failure to appear. Bond will stay set at no bond on both count 1 and count 2. Thank you. Jaden Marrero.
My apologies, Your Honor, we did get Guerrero up here, the one we had, that was POP.
Is this him? Jonathan Guerra? Jonathan Guerra? All right, sir. You were picked up for possession of cannabis with intent to sell or deliver, and I did find probable cause for that charge, but you had already bonded out. You also have 2 violations of probation, and bond is a no bond on both violations of probation. Thank you, sir.
Sure.
So, yes, the on view violations for the new charges. Thank you, sir.
I thought it was just one violation.
For some reason, I have 2.
It's
Let me see if they have the same case number on them. Usually I double check. 1 of 2. Yes.
I have one.
Well, I'll still look anyway, since I'm already looking. Osceola County, violation of probation. Yes, this is just a duplicate, so it's just one.
Yeah. And just on a side note,
Mm-hmm.
when one of my family members paid my bond,
Mm-hmm.
they paid a fee for Osceola, I think Osceola to, because I guess I can't bond out, like there's no way for me to get out.
Well, you know, I have power, but I don't have all power, so I don't really know what to do about that. I would say to tell your family member that you have the Osceola case and you have no bond on it, and tell the bondsman that he shouldn't have accepted a fee for that case, and then go from there.
But yeah,
They said they'll pick you up, so we don't know.
Jaden Marrero. All right, the court finds probable cause in your case for grand theft third-degree bond will stay at $2,500. No contact with the victim, no return to where this incident occurred.
Your Honor, he qualifies for PTR.
Can you confirm, does he qualify for PTR?
yes, Your Honor, he
I will release you on the pretrial release program. No contact with the victim, no return. Thank you, sir. Eddie McCain. Sir, you were picked up on PC warrant for fleeing and eluding a police officer with lights and sirens activated. Bond will be set at $4,000. Resisting an officer without violence, bond stays at $500. Thank you, sir. Tracy Mickle.
He refused, Your Honor.
Defense waive.
All right, as to the charge of possession of cocaine, the court finds probable cause. Bond is set at $1,000. The court will take no action on the out on bond matter. Gina Mullins. Was this charge within a 1,000 feet of something, state?
It says a college.
Yes, and because I didn't see the name of the college in the affidavit. And I didn't know whether they meant convenience store and just wrote college by mistake or what. But I didn't see the name of the convenience store. I didn't see the name of any facility in the probable cause. I can find probable cause of possession, but I'm not sure I can find probable cause within 1,000 feet of a location because they didn't name the location. Do you need 24 hours or shall I just find probable cause for the possession?
Probable cause for the possession.
All right, the court does find probable cause for possession of a synthetic cannabinoid, and bond will be set at $500. You also have a violation of probation, ma'am. Several conditions are alleged to have been violated, so I'm gonna go through them for you. Condition 4, committing a new law violation of possession of a controlled substance without a prescription on or about June 25th, 2023. Condition 4, a new law violation of possession or use of a drug on or about June 25th, 2023. Condition 8, failing to pay $50 per month and you're behind $250 in arrears. Condition 10, possessing, using, or consuming an unlawful substance of methamphetamine as evidenced by a random urinalysis on June 2nd, 2023. Condition 10, possession, using or consuming amphetamine as evidenced by a random urinalysis on June 2nd, 2023. Special condition, failing to complete 20 hours of community service within 100 days. For all of which bond shall remain at $10,000. Thank you, ma'am.
Your Honor, Ms. Mullins has a,
Oh, no action on the out on bond matter.
Thank you.
Thank you, ma'am. I think I lost the. Robert Pagani. The court finds probable cause for possession of cocaine and bond stays at $1,000. Alex Petitfreer. You were picked up for failure to appear, Mr. Petitfreer, and bond will stay set at no bond on both counts of your failure to appear. Thank you, sir. Chad Rivera Rohina. You were picked up on a probable cause warrant for first-degree murder with a weapon. States at no bond. You're ordered to possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of any release. As to the out on bond case, I'm revoking the bond and setting a bond of no bond. Justin Demetrius Rodriguez. As to the charge of possession of cocaine, the court finds probable cause. Bond is set to $1,000. No action on your out on bond matter. John Franklin Smith,
He bonded.
previously bonded per the jail staff. Donald Strickland.
Yeah, my apologies. They have him bonded, but I think he, come on, Smith.
Let me have Smith back. Smith, John Franklin Smith. The court finds probable cause for possession of a firearm by a convicted felon and bond stays at $4,000. Thank you, sir. Mr. Smith? Are you Mr. Smith? Yes. All right, sir, bond stays at $4,000 and you're ordered to possess no weapons, no firearms, and surrender any weapon or firearm to law enforcement within 24 hours of release. Thank you, sir.
I know.
Yes?
Did he, bond?
Smith?
no, it is,
No. It's not bonded.
still open.
Okay, just wanna make sure.
$8,000 bond. An $8,000 bond. So it's not.
Your judge just said it at 4,000. Right?
Oh,
4,000.
oh, I see. The probable cause, yeah, they had doubled it because out of state. I apologize, Your Honor, but that's what it said in the system. I was just letting them know it's open.
4,000.
Yeah, and you said it at 4.
Donald Xavier Strickland? Thank you, sir.
Oh, and Your Honor, one more thing. Could he, return back to Georgia as long as he maintains contact with the attorney? He's from Georgia.
Well, I don't, what says the state? We're talking about Smith still?
Smith, because I guess it's been an issue if it's not in the order that they can return to wherever they reside, Your Honor. And I just want to make sure he doesn't get, a warrant or anything.
Well, can't you just file a motion with the judge?
Yes, Your Honor.
Not you, I mean, whoever is his assigned lawyer.
Yes, Your Honor. Usually at IAs, because they're just here, he's here on vacation and plans to return on the 9th, we ask so that he can go back home to Georgia as long as he doesn't miss any of his court dates. I don't want it to be an issue where he violates the orders.
Is there something in this narrative that tells me he's here on vacation and wants to go back to Georgia, or is that just something he told you?
No, Your Honor, I'm looking at the phase sheet that we get from pretrial services. He's on, he's here on vacation with his family and plans.
Can I get a position? May I get a position from the state?
I don't really know if he's from out of state or not. I did see the address listed as Covington, Georgia.
But if he is from Georgia, do you have any objection to me allowing him to return to Georgia if that's where he's from?
No.
All right, the defendant is authorized to return to Georgia upon release as long as the defendant is present for all future court dates. Donald Strickland. All right, sir, the court finds probable cause for failure to redeliver a hired vehicle. Bond states at $150. Possession of a firearm by convicted felon. Bond states at $4,000. Possession of a firearm by a convicted felon. Bond is set to $500. You're ordered to possess no weapons and no firearms and surrender any weapon or firearm in your possession to law enforcement within 24 hours of release. Thank you, sir. Bryant Thomas.
Yeah, but you gotta out of count.
Bryant Thomas. Mr. Thomas, the court finds probable cause for burglary of a structure and bond stays at $3,500. You're ordered to have no contact with the victim, no return to where this incident occurred, possess no weapons or firearms, and surrender any weapon or firearm to law enforcement within 24 hours of release. Dwantavia Lavon Thomas.
Next person, that's it.
As to your charge of petty theft, the court finds probable cause, bond stays at $1,000. You're ordered to have no contact with the victim and not to return, no action on your out on bond matter. Malachiah Tremble.
Bonded, Your Honor.
Bonded per jail staff. And Jermal Walker. The court finds probable cause for count 1, possession of a controlled substance with intent to sell. Bond stays at $15,000. Possession of cocaine, bond is reduced to $500. And alcoholic beverages or open containers, bond is, the court orders a release on your recognizance. You're ordered to possess and consume no narcotics as a condition of your release. Thank you, sir. Aisha Weston. Bonded per jail staff. Michael Woodard. Sir, you were picked up for violation of conditional release.
Yes, ma'am.
For being arrested by the Lake Alfred Police Department on the 3rd day of April 2023 for new law violations, and bond is set at no bond on count 1 and count 2.
So no bond now. When will I get a bond, Your Honor?
You can discuss that with your attorney, and you'll have to go before the assigned judge to make a motion or a request for a bond.
Okay.
Thank you. Court, what else do I have on the record? Anything else on the record? Okay, but is there anything else on the record? Court stands in recess.
Thank you.
All right, Sharon, in a minute, I'm gonna get a date from my judicial assistant, and we're going to include that date, and it is going to be I asked for a detention hearing date, unless the judge tells me to give him a different kind of hearing. We're gonna have a detention hearing to be set by Judge Whitehead. Would you like for me to hold the defendant here, or you want me to just go ahead on and let him go? And we'll just put the date on his paperwork, Ms. George?
That's what I would like, Your Honor.
Just hold him or let him go?
No, let him go and have a date for him to go back.
All right, sir, Mr. Lucas, I've just given you a bond on the felony case, and I'm gonna set a detention hearing on the misdemeanor case where you will go to the juvenile detention center and see Judge Whitehead or any other juvenile judge for that case. The date will be included on that paperwork, and you will get a copy of the paperwork, okay?
Your Honor.
Yes, sir.
He has a first appearance detainer. The first charge is shooting at within an occupied vehicle. The second charge is possession of a firearm by a minor. It was transferred from case number 2023 CJ 00374-A-O. The new case number is 2023 CF 003274-AO.
Is that this case?
No, there's,
Yet another case?
yes, but it didn't appear, it's 2023 CF 3274, as he's stating, and that is a shooting, throwing into occupied vehicle, and a possession of a firearm by a minor.
So will that one be ready by tomorrow?
That case has already been direct filed.
Okay.
And that case also should also have a bond, but I don't.
Well, but it's not on the docket today, so I'm
No.
asking, will it be on tomorrow's?
And that's the out on bond.
Oh, yeah, he already has a bond on that case. Yes, okay, okay. So we don't have a detainer at this point, because he already has his bond on that case. The 3274 case?
It's treated as an out on bond case, Your Honor. He has,
Oh, okay, well, you all need to use the same terminology, because, I mean, this different terminology I'm not really sure. So just like the regular out-on bonds that I review every single day?
Yes, Your Honor. It was from.
Well, I call them out-on bonds. All right, but we can call them detainers too, I guess. There's all kinds of detainers. Listen, I haven't reviewed that case. Can the state give me some background on the 2023 CF 3274-AO case? What are the charges?
Yes, Your Honor, and that case has already been arraigned. The charges in that case are shooting, throwing into occupied vehicle, possession of a firearm by a minor. There was an arraignment, which was on March 23rd. There was a pretrial conference set May 2nd, 2023.
And what are the bonds?
Let me go.
I don't have listed on Your Honor, is just transferred from the juvenile case.
Yeah, this was a direct file from juvenile, so I'm trying to figure out.
Revoke bonds. And state, you did confirm that information has actually been filed, correct?
Yes, he's already been arraigned on it.
Revoke bond, no bond. Sir, I revoked your bond on a case that you're out on bond on due to the similarities of this case to the current case. I ordered no bond. All right.
you got a conflict. Need is your attorney.
Anything else for this particular defendant before I release him?
Did you set a,
I-
setting a bond on?
No bond. No bond as to the out on bond matter, zero bond. Revoke the bond, no bond.
No, Your Honor, I'm referring to the misdemeanor case. I don't think we addressed it.
I'm giving that a court date.
Okay.
I'm gonna refer that to Judge Whitehead.
Okay.
And for a detention hearing. That case is charged, he's still a juvenile,
Okay, thank you.
okay? And I'm assuming, okay, before I release him, I am assuming he was also direct filed on the 2023 CF 3274-AO case.
Yes.
Yes, Your Honor.
Okay,
He was.
all right, thank you all, and thank you, sir.
Do we have the date for the?
No, we don't have it yet.
Okay.
I'm gonna go back to, I have requested a date for a juvenile detention hearing on the misdemeanor case. And by the way, at the time when I reviewed these, I was really reviewing them from the face sheets and not not these, so I don't have the case number. Can somebody remind me of the misdemeanor case number?
2023 MM 473480.
Okay, 4734AO. And that is the possession of a firearm by a minor and the resisting an officer without violence. I'm waiting to get a detention hearing date for that particular case. So I will be referring back to that case, but I've already released the defendant, and I did appoint the public defender on all cases. All right, okay. I'm gonna move on along now at this time. Try to get my pace going. Thomas Byrne.
Yes, ma'am.
In your case, sir, you're picked up for a violation of your probation. Condition 8, failing to follow the rules of electronic monitoring. And bond will stay set at no bond. The public defender is appointed in your case. Thank you, sir.
Your Honor, he has reporting instructions. He's an HRSO. It's just a reminder for him to make sure to report when he gets out.
So, sir, you are ordered to comply with any conditions of, reporting conditions under Florida law upon your release from incarceration. I don't like abbreviations. I like whole words. Unless it's a VOP, violation of probation, which I know, or DUI, driving under the influence, use whole words. That's a special request from the court.
Yes, Your Honor.
Thank you.
I do have one question, ma'am.
Go ahead.
How long will I be here under the BOP?
I ordered no bond.
Right.
And so you will be there until you have a court date.
That's what I was clarifying.
Until you have a court date, sir.
Okay.
All right, thank you. That's the rest of them. Put them all up here. Y'all, this is the most confusing day of initial appearances I've ever had in my life. Okay, now let me just get back to what I'm confusing myself. Jose Farias.
That's the Spanish.
Okay, Spanish.
Good morning, Your Honor. This is Peresno Leon, certified Spanish interpreter. I have been previously sworn. The interpreter can confirm there is connection with the headsets, Your Honor.
Thank you. The defendant is Jose Farias, case number 2023 MM 490AW. Mr. Farias, the court finds probable cause for battery. I am ordering you to have no contact with the victim. According to this, this happened in a tent situation. Ms. Shorter, is it a permanent tent or is it a movable tent?
Appears that it may be movable, Your Honor, based upon the location. It looks like it's at an intersection in Ocoee at Palm Park and Palm Drive.
So I am also ordering you not to return to the location where this incident occurred, and that you possess no weapons or firearms and surrender weapons or firearms to law enforcement within 24 hours of release. Bond is set at $500. Do we need the interpreter for, the Spanish interpreter for any additional cases?
No.
All right, thank you, Mr. Interpreter.
At your service, Your Honor. Have a wonderful morning.
Now you're gonna call the Creole interpreter.
Yes, ma'am.
Yes. Are you Jackson Saintville?
Yes.
Come to the podium. This is Judge Allen. Is the interpreter on the line?
Yes, this is Michelle. I'm on the line.
All right. We're going to need to swear you in, and then we'll need you to swear in. Sir, do you need the Creole interpreter?
Yes.
Ma'am, do you need the Creole interpreter?
Yes, Your Honor.
All right, we need you to, Sharon, can you swear in the interpreter?
Raise your right hand. Solemnly swear to translate from Creole to English for English and Creole in the testimony given today.
Yes, I do.
Now, we're gonna swear the defendant and the witness in. I'm sorry, just the witness. Defendant just needs to hear.
Okay.
She said she did.
Raise your right hand. Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
Est-ce que vous lever main droit tout et puis tout ça pour le témoigner aujourd'hui, est-ce que tout ça pour le dire c'est la vérité et seule vérité?
Did she answer, Madam Interpreter?
Okay, I cannot hear anything practically, or I hear you very, very far away.
Okay. Tell the victim, do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
Est-ce que vous avez dit toute la vérité, seule la vérité et seulement la vérité?
Oui.
Yes. And have her state her name for the record, please.
Est-ce que vous avez nom, s'il vous plaît, pour dossier? Qui ça?
Marlene E. Fenelus.
Marie E. Fenelus.
No, Marlene.
Ma'am, I need you to speak into the microphone. Miss Interpreter, tell her that.
Marlene E. Fenelus.
Madame, nous besoin qu'on parle dans le micro, s'il vous plaît.
Oui, moi fais ça.
Yes, I'm doing that.
Ma'am, what is your name?
Marlene E. Fenelus.
Madame Kumorele.
Marlene E. Fenelus.
Marlene, qui ça?
Marlene E. Fenelus.
Okay. Marlene E. Fenelus.
All right, Miss Fenelus. Miss Fenelus, please speak into the microphone, ma'am, so that we do not have to ask you to repeat every single thing you say. Would you do that for me this morning?
Est-ce que vous pouvez faire un bagage pour moi, s'il vous plaît, Madame Fenelus? Parlez dans le micro, parlez fort pour nous attendre, pour nous pas besoin de répéter chaque bagage que nous demandons.
Oui, but moi j'ai un petit inconvénient dans la bouche, moi, parce que il a fait mal et moi ouvrir les fort. Pour moi, comme c'est pour m'ouvrir la bouche moi fort, pour me parler, parce qu'il fait moi mal pendant.
Okay, so the reason I'm speaking like that is because my mouth hurts a lot, and it's a lot of effort, and it hurts when I'm talking if I open my mouth wide to speak.
Ms. Interpreter, would you just interpret the following? Ma'am, if you need to step out and take some medication or put some water on your face or do whatever it takes to make you feel better, I'll give you time to do that and we'll call you back later. I don't want you to be in pain.
Madame, moi pas vle qu'on gagne douleur, pas vle qu'on gagne douleur, so sous besoin déplacer pour un moment, passe un petit glou dans figure, prend médicament ou n'a pas autant ça, nous pas vle qu'on gagne douleur.
Do you need some time?
Vous besoin de petit temps?
No.
Non.
Then I need you to speak into that microphone.
Eh bien, dans ce cas, nous besoin parler dans le micro, OK?
Okay.
The state or defense may have questions of you. Please answer the questions.
So, nous allons demander des questions et on va répondre aux questions.
Okay.
Okay.
Good morning, Ms. Fenelus. This is the State Attorney, Assistant State Attorney, Ms. Shorter. Do you want any contact with Mr. Saintville?
Ok, moi-même, moi, c'est avocat aujourd'hui, hein, Madame Fenelus. Est-ce que vous avez gagné, moi, les Madame Shorter, est-ce que vous voulez gagner contact avec Monsieur Saintville?
Non.
Non.
Do you live with Mr. Saintville?
Est-ce que vous habitez avec Monsieur Saintville?
Non.
Non.
Thank you. No further questions.
Defense?
Pas une autre question.
No questions, Your Honor.
Pas une question non plus.
Miss Interpreter, please interpret the following. Sir, I find probable cause for battery by strangulation
Ok, so kounye, moi, ouais que gagné cause probable que yo t'a essayé pour trangler.
and for battery dating violence.
I'm sorry, for battery, you said the word in between battery.
You qualify for pretrial release, and I will order that you be released on that program.
So, ou éligible pour yo lage ou pour pré-trial, pour avant et tribunal la, audience là.
The conditions of release are that you have no contact whatsoever with the victim,
Une condition que n'a plague là, c'est que ou pas aucun contact avec victime là.
and that you maintain separate residences,
Et que ou kembe ou l'autre résidence séparée, nous habiter séparément.
and that you possess no weapons and no firearms,
Et que ou pas aucune arme.
and surrender all weapons or firearms in your possession to law enforcement
Et que si vous gagnez aucune arme kounyen, ou après mettre toute bagaille by la police.
within 24 hours of your release.
Avant 24 heures de temps, le lage au lan 24 heures de temps.
I also have appointed the public defender to represent you.
Et moi déjà employé, m'a signé un public defender pour un défenseur public pour représenter.
Do you understand, sir?
Est-ce que vous comprenez, monsieur?
Yes. Yes.
Thank you. Thank you, ma'am.
OK, merci. Merci, madame.
The next case requires an interpreter as well. Madam Interpreter, we have a second case for you. Frisnell Labosieri,
La Bossière,
and Mr. Labosiere,
Oui.
I find probable cause in your case for battery, domestic violence.
et moi joins dans dossier où que ou gagnez ou fait violence domestique.
You are ordered to have no contact with the victim,
Ou pas ou supposé pas avoir aucun contact avec victime là.
you're ordered to not return to the location where this incident occurred,
Ou pas gen droit retourner côté où incident ça a arrivé,
with the exception of a one-time visit with law enforcement if needed to collect personal items,
seulement ou gagné pour aller accompagner pour la police pour qu'à prendre affaires personnelles.
you're ordered to possess no weapons and no firearms,
Ou pas supposé gagner pour aucun arme en possession.
and surrender all weapons or firearms in your possession to law enforcement within 24 hours of release.
Et ou supposé remettre toutes les armes qu'on gagne avant 24 heures après que vous l'avez.
I've also appointed the public defender to represent you.
Et moi assigné un défenseur public qui pour représenter.
Do you understand?
Est-ce qu'on comprend?
Mba kompren kek ba mba kompren.
There's a couple of things I don't understand.
Go ahead. If I can answer it, I will.
Ok, si mka repon yo, map repon yo ki so pa kompren.
Paske mwen pa gen oken zam pou mwen remet, paske mwen pa gen.
I don't have any weapons to give to the police.
Speak up, misinterpreter. Repeat that.
I don't have any weapons to give to the police.
If you don't have any weapons to give to the police, then you do not have to give them any weapons.
Sou pa genyen zam, ou pa bay zam, ou pa genyen.
You must only give them weapons if you have them.
Se seulement si ou genyen que wap remet la police zam yo.
Non, nou pa gen.
No, I don't have any.
Is there anything else that you don't understand?
Est-ce que de kon lot bagay ko pa kompren?
Oui, tankou ti moun yo. E koman mwen men kapap fe si mda bejoun re ave yo.
How about the children? What am I supposed to do in order for me to see them?
How old are the children?
Ki l'âge ti moun yo?
2 ans, 7 ans.
2 and 7.
Was DCF involved in this case, Ms. Shorter, to your knowledge?
Not to my knowledge. Not sure if they'll come later. It says that the officer did call Department of Children and Families and spoke with someone who would then initiate an investigation.
You let me know if I need to interpret any of that, or?
I am ordering that you also comply with any DCF order that might be entered.
Ok, m'a dit tout que n'importe que l'ordre que DCF ba ou supposé suivre ça yo dit yo, suivre règle que ba ou yo.
D'accord.
Ok.
Thank you.
Ok, merci.
Did I give you his paperwork? One moment, Ms. Interpreter, and one moment, sir.
Sure, sure. Donne-moi un moment, monsieur.
Ms. Interpreter, one final thing.
Yes.
I am also ordering a bond of $500.
Ok, et puis ou gagne pour payer $500 amende.
D'accord. Mais est-ce que moi pas venir avec l'argent? Est-ce que nous pas autoriser mon papier juste pour me te payer comme ça côté me payer là s'il vous plaît?
I didn't bring any money with me today. Can I have a paper that will authorize me to pay it when I have the money?
You will receive paperwork, and you will need to make arrangements to bond out on your behalf.
Ok, so ou ap recevoir papier et ou ap fait arrangement ou capable payer.
D'accord. Merci beaucoup.
Ok, thank you.
Thank you. Do we need the interpreter for any additional Creole cases?
No, Your Honor.
Ms. Interpreter, thank you.
Okay, my pleasure. Have a nice day.
You have a nice day, too. The next case is David Gervin. So,
He was reset, Your Honor, for a plea.
is this Mr. Gervin?
Yes. And, Your Honor, the offer that the state made to resolve the case, both charges, is an adjudication of guilt, credit, time served, and court costs. And Mr. Gervin would like to accept the state's offer and enter a plea of no contest.
All right, what is the time served on Mr. Gervin? Mr. Gervin, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine?
No, ma'am.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
All right, sir, I've reviewed your file. There's a sufficient factual basis to accept your plea, and I will do so. Because you are alert and intelligent, I will adjudicate you guilty. Order 3 days in jail with credit for 3 days time served, and order you to pay all mandatory court costs associated with your charge through the clerk's payment program within 365 days of your release. And I am ordering your release as to this charge, but if you have any other case holding you in jail, you may need to resolve it before getting out of jail. Any questions?
Ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date.
Yes, ma'am.
Jason Beard.
Yes, Your Honor.
One moment, Mr. Beard. Cause I don't, no, it's like, these are like here's St. Ville, which I've already done. And here's Byrne and. Yeah, when I write notes, I gotta keep them. Wait a minute, were those already done though?
He gave you his and yours.
Oh, okay, here's Mr. Beard. Yeah. Yeah, okay. Mr. Beard, sir, I find probable cause for aggravated assault with a firearm and battery. Count 1 bond is set at $1,500. Count 2 bond is set at $500. You're ordered to have no contact with the victim, possess no weapons, no firearms, surrender weapons or firearms to law enforcement within 24 hours of release. You're ordered to not return, with the exception of a one-time visit if needed in the presence of law enforcement to recover personal items. Thank you, sir. Kayla Emery. Ms. Emery, the court finds probable cause based on a PC, or you were picked up based on a PC warrant. There's probable cause for child abuse. Bond is set at $3,000. Neglect of a child bond is set at $1,000, and neglect of a child bond is set at $500. You're ordered to have no contact with the victims and no contact with any minors under the age of 18 without supervision. Possess no weapons or no firearms, and surrender weapons or firearms to law enforcement within 24 hours of release. You are ordered to comply with any DCF order. If DCF reviews and allows contact, then you are authorized to have contact with the victims pursuant to the DCF order only. But otherwise, no contact.
Your Honor, she would like an ankle monitor as opposed to the monetary bond, as she can't post the monetary bond. I know they started back doing the ankle monitors,
When?
right? We did some on another client, the ankle monitors.
Yes, when did they start back doing the ankle monitors?
We haven't.
We had a client that did, okay. Well, they don't do it.
Okay, I just have a question because I came back from Massachusetts. I no longer live in Massachusetts no more. I mean, in Florida, I resigned in Massachusetts. I did a whole 180. I do have DCF. My kids are being held in DCF custody in Massachusetts. And I do got a job. I just got my apartment on my keys. So I was seeing like if there's like a way where I can do like pre-trial or.
Hold on a minute. So the kids are already in Massachusetts, Ms. George?
Yes.
All right, and DCF has already entered an order in Massachusetts?
Yes, I'm already involved in Massachusetts
Okay.
DCF. They said that they want me to do therapy and parenting classes, but I can't do that unless I'm up there. I literally took the time out of myself to come down in Florida and handle this. I turned myself in yesterday at the courthouse. This is like, everything is all new to me, and I did do a whole 180. I got my keys on the first. I got my job. I literally just got my job, and I get my third paycheck yesterday, so I got pay subs.
I would, give her, if I could see the DCF order, I would
I
definitely.
actually have the number. I'm so sorry. I have Roxanne's number. Her name is Roxanne. I have Gerard. The case number, I'm not too sure, but they are in DCF custody. I have my attorney. They go to court July 20th in Massachusetts. I have my DCF. They said that I can see my kids as long as it's supervised and everything.
So, several concerns, ma'am. The DCF order is paramount to me. Seeing the DCF order could assist me in, responding to some of your concerns. I don't know anything about ankle monitors, and so I don't know that that would be what I do. But, if I could see the DCF order and review the DCF order, it will go a long way towards, helping me to at least consider what I believe your concerns are. Can either the state or defense provide me with a copy of the DCF order?
I'm trying to see if I can pull up a DCF order, because it looks like the incident occurred here in Orlando. Not sure she has a separate case in Massachusetts. The kids may be placed there.
I do not. The kids are placed in DCF in Massachusetts. They did pick up my kids.
But the case will be here.
So the, state, let me ask you if you're familiar, so, because I don't know, I'm not familiar, but if a kid is out of state, when something happens, does the Florida DCF transfer the kid back to the state where the kid is from?
It depends. So the court can ask for intervention. It depends on how long they've been here. The court can ask for emergency intervention from Massachusetts. They can say, yes, we want to take the case, or no. However, and I'm just trying to see if I can find a DCF case here. But what also could happen is, because they were, there's family out of state, they can initiate an ICPC home study of family in Massachusetts. And then at that point, have the children placed with family in Massachusetts pending a DCF case here in Orange County. But I'm just trying to see if there's a pending DCF case here in
They are in
Florida.
state custody, but they did let them go to my sister's house, so they're living at my sister's house, but in state custody
Okay,
in Massachusetts.
all right.
When they come in on the warrant, have it on there? Orange County. Yeah, we don't have,
I'm not seeing, I just see the child abuse.
Can you confirm that she turned herself in, or?
Yes, I have my paper right here. I literally went to the court yesterday, and I literally turned myself in. I just resigned. I went to the clerk, seeing if I could speak to a judge about this matter, because I do have another life in Massachusetts. I do not reside in Florida no more, so it's like I'm trying to figure out, but I did came and turn myself in.
Okay, it does indicate that she was in room 410 at the courthouse when she was arrested. That's different than turning yourself in. Turning yourself in, you kind of have to come to the jail for
See, I
before.
didn't know that. I didn't know nothing about
You
that.
didn't turn yourself in. Turn yourself in is done at a jail, not at a courthouse.
I thought to arrange a warrant, you had to go to the courthouse. I didn't know nothing about it.
You came to court, you didn't turn yourself in. Any luck on finding that warrant, DCF order?
I'm looking, it shows something from Massachusetts. I'm just trying to go through
Mhm.
CIS. So it looks like the warrant was issued on June 13th under the CF 237857A. It appears as if this was a at-large case. Let's see. It was an affidavit for the warrant. It was signed June 13th. She was not arrested at the time the incident occurred. The alleged incident occurred.
I read the PC for this case.
Going through it looks like the alleged incident occurred prior to April.
Yeah, I don't remember the date it occurred, but I did, it was a PC warrant, but I read the entire narrative because I wanted to have some idea of what type of abuse was being alleged.
I have it. I just read through it.
I just, really, the only thing that can help her now, for me, is if I see the DCF order, nothing else. Otherwise, my order on bond stays 3,000 on count 1, 1,000 on count 2, 500 on count 3, unless
Unless you guys need to speak to my attorney, Gerard, or the DCF worker, I do have their number. If you guys can call, they are accurate. I have Gerard, he's my lawyer for the DCF. Roxanne is my DCF caseworker.
Ma'am, from what you're saying, it sounds like a lot has occurred up in Massachusetts. But I'm not sure if anything that has occurred in Massachusetts has anything to do with what happened in Florida.
They don't know, they can't do nothing right now because they're trying to figure out what they're gonna do with me. That's
So,
why
so just hear me out, ma'am. This is why I need to see the order. If I see the order and the Massachusetts order somehow has taken into consideration the case in Florida, then I can consider that.
Yes, ma'am.
However, Florida has its own DCF, and if DCF has not already reviewed this matter and done what the state has asked and asked for an emergency intervention from Massachusetts, then my DCF in the state of Florida has not assessed this case. And I need my DCF to assess this case unless they've already done so. I have no reason to believe that they have. I also don't know for sure. But the only way I could confirm it is seeing the DCF order because it would indicate the basis for DCF being involved in you and your children's life. So my ruling is going to stay the same. That gives the DCF in Florida an opportunity to assess this case and enter any order they believe is appropriate, consistent with the charges in this case, as well as, of course, the bonds that I have set. Now, the last thing I'll say is I have appointed the public defender, and the public defender may receive additional information. They may be able to get that DCF order or some other information, if not that, if they want to try and argue for a reduction in bond or a release based on some other status, your lawyer may do so. And I have appointed them to represent you in this case. Thank you, ma'am. Joseph Gomez.
Medical, Your Honor.
Medical.
It's a waive, Your Honor.
All right, the court finds probable cause for aggravated assault with a firearm, domestic violence, and sets a bond of $1,500, and grand theft sets a bond of $500. No contact, no return, possess no weapons and no firearms, surrender weapons and firearms to law enforcement within 24 hours of release. A one-time visit with law enforcement is authorized if needed to recover personal items. Nathaniel Graham. Raise your right hand to be sworn in.
Do you solemnly swear or affirm the testimony shall give you the truth, the whole truth, and nothing but the truth?
Yes.
State your name for the record.
Cheyenne Wheeler.
Ms. Wheeler, please continue speaking into that microphone just like you're doing now and answer any questions that may be asked of you. Go ahead, state.
Good morning. I'm sorry, I just want to make sure I have the right, Mr. Graham. Can you please state your name?
Cheyenne Wheeler.
Do you currently live with Mr. Graham?
No,
And you're listed as a victim in this case. Do you want contact with him?
yes, I want contact because I got all my items back and I called the officers. The officers still pursued the case, and that's why we're here.
Well, there's a couple of charges. There's a battery, and then there's the criminal mischief and the grand theft. I'm only speaking as to the battery.
Okay.
Do you reside with him?
Yes, I'm good. I can still contact.
And
have no
if
fear.
another incident occurred, would you call law enforcement?
Yes. Oh,
One moment, one moment. I just need to talk to Judge Whitehead. One moment, I'm sorry, ma'am. I have to talk to another judge. Give me a moment.
Okay, that makes sense. So,
Ma'am, I do apologize for breaking into your hearing. I just don't like to ignore a call from another judge, especially since I knew it's about a case. But he understands I'm in court now, so we're gonna go ahead and continue. You may continue.
Just that you would call law enforcement if another incident occurred?
yes, I will.
Okay, thank you. No further questions.
Defense?
no questions, Your Honor.
All right. The court does find probable cause for battery, domestic violence, and sets a bond of 500. Criminal mischief, I'll set a bond of 500, and grand theft bond is set at 100. You're ordered to have no hostile contact with the victim, and you're ordered to possess no weapons and no firearms, surrender any weapons and firearms to law enforcement within 24 hours of release. Thank you.
All right.
Deidre Ashley Haney. As to Haney,
Yes, ma'am.
the court finds probable cause for aggravated assault, domestic violence, and sets a bond of 1,500. Grand theft bond is set at 500, and criminal mischief bond is set at 100. I am, on your auto bond case, I am revoking the bond on 2023 CF 524AO and ordering a bond of $30,000. On the other case, 2022 CF 318, I couldn't find it. The other case, 2022 CF 3187, because there's no, I don't know where that case is from. I couldn't find it in the Odyssey.
Osceola, Your Honor. Yes.
It's Osceola. How do I know whether it's been filed on or not?
I can check.
Can you check for me? Okay. Oh, it does say that right on here, Osceola. Well, I looked all through the Odyssey. I put AO, AA, AE, AW, and then I gave up. And I didn't read that it was from Osceola. But I wouldn't have been able to find it anyway because I don't have access to Osceola Odyssey. At least I don't think I do.
I can't see it.
And it's been filed on.
Yes.
Yes, ma'am, it has been.
22-3187, Osceola County has been filed. There is a pretrial conference which was set for yesterday. It's set to plead July 14th. Also, there's a trial date of July 18th.
Based on the nature of the charge, I'm revoking the bond and ordering a new bond of $10,000. Further, I'm ordering you to have no contact with the victims in any of your cases.
Thank you.
Possess no weapons, no firearms in any of your cases. Forfeit or surrender any weapons or firearms to law enforcement within 24 hours of release and not to return to where these incidents occurred. Michael James.
Yes, ma'am.
Mr. James, in your case, The court, you were picked up on a PC warrant, and the court does find probable cause for false imprisonment with a weapon. Bond is set at $5,000. Use of a firearm or weapon in commission of a felony, bond is set at $5,000. Possession of a concealed weapon by a convicted felon, bond is set at $1,000. Aggravated assault with a firearm, bond is set at $1,000. Battery, dating, violence, bond is set at $500. And assault, domestic violence, bond is set at $150. You're ordered to have no contact with the victim in this case, possess no weapons, no firearms, surrender any in your possession to law enforcement within 24 hours of release. Further, you are ordered you are allowed to have a one-time visit with law enforcement if necessary to recover any personal items or effects. Thank you, sir. Patricia James. The court finds probable cause for obstructing justice. Bond is set at $500. Criminal mischief, bond is set at $100. And battery, dating, violence, bond is set at $500. You're ordered to have no contact with the victim, no return, with the exception of a one-time visit if necessary to recover personal items. Possess no weapons or no firearms, and surrender any weapon or firearm to law enforcement within 24 hours of release. Thank you. Gabriel Oliver. Thank you, ma'am. You were picked up on a PC warrant, Mr. Oliver. And probable cause is found for aggravated battery on a pregnant person. Bond is set to $5,000. Count 2, aggravated battery on a pregnant person. Bond is set at $1,000. And count 3, burglary of a conveyance with an assault or a battery. Was this with a weapon or without a weapon, Madam Prosecutor?
Without. It says with, but I'm gonna go into the file to see.
All right, bond is set at, if it's without a weapon, bond is set at $10,000. It says without, it does not say with, I'll put it that way.
I'm just gonna read really quick to see if they found one.
Your Honor, in count 2,
Yes, ma'am.
what did you set the bond at?
1,000.
Thank you.
Further, I am ordering on the out on bond case, 2023 CF 5457. I didn't look at that one. Madam Prosecutor, has that case been filed on?
So the one that we just spoke, I don't see a weapon.
I confirmed that, yes, ma'am. It does not indicate there was a weapon, and I did set a bond of $10,000.
Okay.
On count 3.
Other case.
2023, looks like CF 5457.
It's our case, Your Honor. It has been filed on.
Okay, the court will revoke the bond and set no bond. Further, I am ordering you to have no contact with the victims in any of your cases. Surrender any weapons or firearms to law enforcement within 24 hours of release, and possess no weapons or firearms upon release. Jacqueline Smith.
Good morning, Your Honor.
Jacqueline Smith.
Good morning, Your Honor.
Good morning. The court finds probable cause for aggravated battery with a deadly weapon, dating, violence. Bond is set at $1,500, and possession of tetrahydrocannabinols. The court will order a bond of $500. Further, I am ordering you to have no contact with the victim, no weapons, no firearms, no return, with the exception of a one-time visit in the presence of law enforcement. Surrender any weapons or firearms to law enforcement within 24 hours of release. Berskely Vega.
Mental health, Your Honor.
Defense away.
All right, the court finds probable cause for child abuse and orders no contact with the victim, no contact with minor children under the age of 18 without supervision, and comply with any DCF orders that may be entered in the case. Jason Wright.
What's the amount of bond? I'm sorry, Your Honor, excuse me. I did not hear the amount of bond for the last case for Vega.
$1,000.
Thank you.
All right, as to Mr. Wright, Mr. Wright, the court finds probable cause for battery by strangulation. You qualify for pretrial release. I'll order pretrial release and order you to have no contact with the victim, no return with the exception of one time with law enforcement if needed for personal items, possess no weapons, no firearms, and surrender any in your possession to law enforcement within 24 hours of release. Thank you, sir.
Thank you, Your Honor.
Malika Janisha Ben-Ami. In your case, Ms. Ben-Ami, there's a witness. Raise your right hand to be sworn in. Speak into that microphone.
Hello, how you doing?
Hi.
Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
Yes.
State your name for the record.
Robert Zamore.
Microphone.
Robert Zamore.
Moore?
Robert Zamore.
Zamore?
Yes.
Okay, Mr. Zamore, you can take your hand down now. Someone may have questions of you. Please answer the questions. Please do answer into the microphone best as you can, okay?
Yes.
State, you may inquire.
Hi, good morning. Mr. Zamore, do you reside with Ms. Ben-Ami?
What was the question again?
Do you reside with Ms. Ben-Ami?
What do reside mean?
Live together?
Yes, yes.
Thank you. And at this time, do you want to have contact with her?
Yes.
If another incident occurred, would you be able to call law enforcement? Would you comply with that?
Yes.
Okay, no further questions.
Defense has no questions, Your Honor.
The court finds probable cause for battery, domestic violence. I'll order a bond of $500. I'm ordering you to have no hostile contact with the victim, possess no weapons or firearms, and surrender any weapon or firearm in your possession to law enforcement within 24 hours of release. Any questions, sir?
Yes, I do have a question. What time will she be released?
There is a bond of $500.
Okay.
Upon the posting of a bond, on this case, she may be released.
I have another question. So, she usually has all the funds and stuff. So, would she be able to get out and like work something out so she can be able to pay for the bond?
How old are you?
I'm 31. No, 32.
32. Well.
But it was just like a miscommunication.
You don't have to tell me that. The only reason I asked your age is because I was thinking that maybe you should know how to assist her with that if that's what you want to do. I don't know. I don't know how to answer that question. I really don't. That's a question for a bondsman. Maybe if you go to a bondsman, if you are trying to assist her to bond out, perhaps the bondsman who has done this so many different times can assist you with information.
And Your Honor, since I know additionally they couldn't get an alternative address at the time and phone number, but since she's allowed to return back home, she would likely qualify for pretrial release. So could we do pretrial release, Your Honor?
Yes.
Thank you.
I'll order pretrial release or the bond, either or. So if she qualifies for pretrial release, she appears to qualify, then she does not have to post the bond. But at 32 years old, you should know how to help her. Okay, thank you.
Can she be a straight PTR? Is that good?
Yes, given that the defendant does qualify, I will do just straight pretrial release. No bond is necessary.
Thank you, Your Honor.
Thank you, ma'am. Thank you, sir.
Thank you.
Ronique Davis. In your case, the court, you were picked up on a PC warrant. There's probable cause for battery, domestic violence, and you do qualify for pretrial release. You're ordered to be released on the PTR program. I am ordering you to have no contact with the victim possess no weapons, no firearms, surrender weapons or firearms to law enforcement within 24 hours of release. Further, I am ordering a one-time visit with law enforcement if needed to recover personal items, and thank you. Joanne Irvin, Irvine?
Your Honor, would you be inclined to give a $500 bond as opposed to pretrial release?
No, I would be inclined to do pretrial release. Joanne Irvin. In your case, the court finds probable cause for battery, domestic violence, and, so this is the mom and son. Did I already do the son?
And Your Honor, could we also, her brother is also in here. He was arrested as well. Where's his?
Mom, son, and brother? Okay, I didn't catch the connection with the brother. All right, do you have any more facts about the living arrangements in this case? Because I knew I had the mom and the son. I didn't realize I had the brother. Is it the brother of the son or the brother of the mother? The uncle or who is he?
It's me and my son, Your Honor.
It's two.
Okay.
I have a Lewis Jonathan.
That's my son, Jonathan Lewis.
That's the son.
I'm Joanne Irvin.
I don't know anything about a brother.
Yeah, there's no brother.
I meant brother. I'm sorry, Your Honor.
That's my son.
What do you mean?
Son.
Sorry. It's the son.
Yes, Your Honor.
So no brother?
No, Your Honor.
All right, so do you have any information about the living arrangements between her and her son?
No, Your Honor.
Okay.
Could I?
Because her son should be coming up in a few minutes, if he isn't already, if I haven't already done it.
You want him to come now, or you want him to come separate?
Ms. George, you want him to come now?
Yes, Your Honor. I was gonna ask if we could have them together and see if they want contact.
Jonathan Lewis.
I just want to be respected. I'm just not respected. I'm scared of what just happened. I'm scared.
Ma'am, is this Jonathan Lewis?
Yes.
Okay, all right, and, sir, you are here for a charge of battery domestic violence. And ma'am, I've already informed you, you are here for a charge of battery domestic violence. The battery domestic violence charge as to Miss Urban, Mr. Lewis, you're the victim. You understand? And the battery domestic charge as to you, Mr. Lewis, Miss Urban is the victim. Do you understand, Miss Urban? Everybody understand? And it happened at the home. And I am about to enter an order of a bond. I'm gonna give a bond in both cases of $500 to each of you. Hold on a minute. Well, don't ask a question just yet. I'm gonna tell you why I brought both of you in. I'm gonna order that you possess no weapons and no firearms in both of the cases, and that you surrender any weapon or firearm to law enforcement within 24 hours of release. The only question that I cannot answer at this time is whether to order you not to return to the home, because I'm not sure what the living situation is, and I'm not sure whether you all are able to be in the home together without having hostilities towards one another. So Ms. George has already spoken to Ms. Urban, and Mr. Lewis, I don't know if she's had a chance to speak to you, so I just kind of need to know what is the situation before I can enter an order. Do you all understand why I have both of you here now? You understand that, Mr. Jonathan? Sorry, Mr. Lewis? Okay, so.
Can I ask him just one question, because I've already spoken?
Yes, ma'am, you may.
I was gonna move out anyway, cause that's what she want anyway.
Okay.
I just ain't got the money for no bond because I get Social Security every month, and she knows that.
One moment, sir. I'm gonna let the state, the defense counsel, let me know.
Okay,
I'm
Your
just-
May, it's hard because I'm representing both. Can we approach on this? It's
Yes, ma'am. I have heard from the defense counsel and the state have provided me some background, and I am going to order no contact. In both cases, no contact. I am, based on what I have just heard, please correct me if I have an incorrect misunderstanding. Ms. Irvin is either the owner or perhaps she has some type of interest more in the home than Mr. Lewis. Is that correct?
Yes, Your Honor.
All right. Is it an ownership situation or is she a renter?
She owns the home.
All right. So I am ordering that Mr. Irvin, Mr. Lewis, wrong last name, Mr. Lewis, be allowed a one-time visit in the presence of law enforcement to recover personal items. And Ms. Irvin just is ordered to have no contact. Mr. Lewis, yes, sir.
That's gonna be a problem because I don't have any money till the first.
Perhaps,
The money that I have.
one moment, sir, one moment. Sir, perhaps a family member will assist you in posting your bond, and you just need to remember that you cannot reside in the home at this time, I am appointing the public defender, even if the public defender has to conflict off one of the cases. The public defender is appointed, so you do have a lawyer also to represent you, as well as your mom also has a lawyer. Ms. Irvin has a lawyer. Thank you both. Thank you. John Fairchild. Mr. Fairchild? You qualify for the pretrial release program. I do find probable cause for battery and order your release on that program. You're ordered to have no contact with the victim, no weapons, no firearms, surrender any in your possession to law enforcement within 24 hours of release, no return with the exception of a one-time visit with law enforcement to recover personal items. Cameron Gold. Cameron Gold.
Can I call?
You have a question?
Yes, I did have a question.
Go ahead.
Everything I own is in that house.
That's why I gave you a one-time visit with law enforcement to recover personal items.
Okay.
Cameron Gold. The court finds probable cause for battery, domestic violence, and I am ordering you to, a bond of $500, ordering you to have no contact with the victim, no weapons, no firearms, maintain a separate residence, surrender any weapons or firearms to law enforcement within 24 hours of release. And thank you, ma'am. Ronick Reynolds.
Mental health, Your Honor.
Defense will waive.
All right, defense is waiving its presence. The court does find probable cause for battery, ordering no contact with the victim, no contact with the minor child. The court is except for if in compliance with a DCF order. No weapons, no firearms, and surrender any weapon or firearm to law enforcement within 24 hours of release. No return. Shantae Robinson. Ma'am, in your case, you qualify for pretrial release, and I do find probable cause for battery, domestic violence, and I'm ordering you to be released on PTR and trespass, and also ordering PTR. You must maintain a separate residence, have no contact with the victim, possess no weapons, no firearms, and surrender any weapon or firearm to law enforcement within 24 hours of your release, and thank you. Thank you, ma'am. Alexandria Bland. You were picked up on an out-of-county warrant from Polk County. Bond will stay at no bond on that case. Thank you, ma'am. Yes, ma'am.
You know when Polk County will come get me, ma'am?
Ma'am, no, I don't know.
I'm sorry.
I don't know when they'll come. Hasim Fostuck, you were picked up, sir, on a fugitive warrant from New York. New York, bond will remain at no bond as to that warrant. Thank you, sir. Angelica Jack, you were picked up on an out-of-county warrant from Volusia County. Bond stays at no bond, Ms. Jack. Thank you.
I just have a question. Do you know how long it takes them to come, like?
No, ma'am.
Okay.
I don't know.
Thank you.
Danye Alonzo Knowles, you were picked up on an Mr. Knowles? Yes. You were picked up on an out-of-county warrant from St. Lucie. Bond will stay at no bond. Thank you, sir.
My bad, I didn't hear you.
Yes, sir. You were picked up on an out-of-county warrant from St. Lucie for violation of probation, and bond is going to stay at no bond. Thank you, sir. Reggie Rayshon Madison. Madison. All right, so you were picked up on a fugitive warrant from Memphis, Tennessee, and bond will stay at no bond. Thank you. George Diego Rivera.
Good morning.
Good morning. You were picked up on an out-of-county warrant from Seminole County, 3 counts, and bond will stay at no bond on each of 3 counts. Thank you. Thank you, sir.
You're welcome.
Tidiana Williams, you were picked up on an out-of-county warrant from Seminole County. Bond will stay at $2,000. The court takes no action on your other case. Thank you, ma'am. Eric Davis, sir, you're picked up for violation of your probation. Condition as follows. Condition B, by failing to remain confined to your approved residence except for 1/2 hour before and after approved employment on or about June 5th, 2023. Additionally, Condition 2, by failing to pay the state of Florida the amount of $20 per month cost of supervision and being $180 in arrears. Bond will stay at no bond, and I am appointing the public defender to represent you, as, even though you said he didn't qualify, but he qualifies on no bond status. Public defender is appointed. Y'all need to change that where it said does not qualify, because he does, now that he's in jail. Albert Gilrith, in your case, sir, you're picked up for violation of your probation, condition E, failing to live without violating the law, committing criminal offense of carrying a concealed firearm on 9/15/2022. Condition D, by leaving your county of residence without first procuring the consent of a probation officer on 9/15/2022. Bond will stay at no bond. Thank you, sir. Hanson Harrison.
You refused, Your Honor?
Defense away.
Defense is waiving as present. Defense was picked up for on-view violation of probation. Bond stays at no bond. Okay. Elroy Hernandez Mezquita.
Yes, ma'am.
In your case, you were picked up for violation of probation. Condition 1, failing to report to the probation officer as directed on 4/24/23. And bond will stay at no bond. And on your second case, a violation of probation, bond stays at no bond. The court will appoint the public defender to represent you in this case. So, you don't need to change that one. Since he's on no bond, he does qualify for the public defender. Canada Janae Johnson.
Medical, Your Honor?
Defense
Medical. Defense is waiving his presence. There are 4 cases for violation of probation. Bond stays at no bond on all cases. Actually, one case was a PC warrant for larceny. Bond stays at 2,000. PC warrant for battery. Bond stays at 500. PC warrant for the other battery. Bond stays at 500. Violation of probation. Bond is at no bond. As to the 2 battery charges, no contact with the victim. No return, no weapons, no firearms, surrender weapons or firearms to law enforcement within 24 hours of release. Liddell Omar Johnson. You are picked up for violating your probation, condition E. Committing the criminal offense of battery domestic violence on June 17, 2023. Bond stays at no bond. Kervins Pierre, you're picked up for a violation of probation, condition B. Changing your residence without first procuring the consent of a probation officer on February 3rd, 2023. Bond stays at no bond. There are additional conditions. A special condition by failing to successfully complete 75 hours of community service at a rate of 10 hours due within 90 days and 8 hours each month thereafter. Failure to complete an aggressive driving course within 60 days, and failure to report to the probation officer as directed. Bond stays at no bond. Thank you. Kevin Ramroop, you're picked up for violation of your probation special condition. Failing to successfully complete a batterer's intervention program on or about June 22nd, 2023. Additionally, condition B, by failing to remain confined in your residence except for 1/2 hour before or after approved employment. Bond stays at no bond. Thank you, sir. Michael Rodriguez, you were picked up for an on-view violation of probation for a new law. Bond stays at no bond. Daryl Sasser. You were picked up for an on-view violation of probation for a new law. Bond stays at no bond. Nikki, that's it, sir. Thank you. Nikki Andres Velasquez Santiago. Sir, you were picked up for a violation of your probation. Condition 7, violating the Sex Offender Probation Jessica Lunsford Act by accessing the internet or other computer services until a qualified practitioner in the sex offender treatment program, after a risk assessment is completed, approves and implements a safety plan. Bond will stay at no bond.
Your Honor, he
Yes.
has the reporting instructions for the high-risk sex offender.
Sir, you are ordered to comply with all reporting requirements under the state of Florida law upon any release from incarceration. Thank you, sir. You got 33 days? Okay. These are from yesterday?
Whatever was it then.
You have a new
Ms. Shorter?
Yes.
Donovan Stinnett, case number 2023 MM3027AO, and then after that, you call through them, please.
Yes, on Danette, Your Honor, I have spoken to the trial ASA, and she is in agreement with the motion, so we would say the motion can be granted.
All right. As to Stinnett, the motion to release is granted, release on recognizance is granted. Oh, there's only one more case?
Not for Mrs. Stinnett.
Oh, just for Mr. Stinnett. All the rest of them are for different people?
Yes, ma'am.
Okay. Go ahead, Madam Prosecutor.
For CF 23-738.
Name first, please.
Oh, the Jared Burns. Division 22 CF 23-7385AO. The state has filed on that case.
Denied.
Lamar Thomas, 2023 CF 7339AO. The state has filed a notice of non-filing on that case.
This motion is granted.
Case for Lamont Jawani, which is 2023 MO66A. That is a City of Orlando case. At this time, we would not respond.
The city's not present to address this case. They have not filed any objection. The motion will be granted.
Marcus Mack, 2023 CF 25.
Oh, wait, back to Mr. Nance, I'm sorry. If this is a city case, the city was not noticed. In fact, it was the state that was noticed. The motion's denied. As this is the Jamon Lamont Nance.
Yes.
2023 MO 668AO. And so the city has not contacted you or someone, your counterpart, this morning to let you know what their position is on this motion?
No, Your Honor.
Okay, so the city may not have received notice, and so therefore I'm gonna deny the motion without prejudice.
For Marcus Mack Jr., CF 23-2565AO. The state has not filed on the case.
I'll be granting that motion.
For Dominique Sanders, 2023 CF 7451AO. The state has not filed on that case.
My motion's granted.
Michael Brett Michael Dye,
Mm-hmm.
2023 CF 75780. The state has not filed on that case.
That motion is granted.
For Damon Anthony Davis, 2023 CF 744680. The state has not filed on that case.
That motion is granted.
For Eric Holcomb, 2023 CF 751880. The state has not filed on that case.
Holcomb?
Holcomb. Eric Holcomb.
Hold on a minute. My orders may not be your order. As to Holcomb, the motion is granted.
Greg Hart.
Wait, one moment.
Okay.
All right, let's assume not. Go ahead.
Greg Demetrius Parks, 2023 CF 737580. The state has not filed on that case.
I'm granting the Parks motion.
Okay.
Madam Clerk, a lot of these have June. Please correct it and make it July.
Okay.
They're slowing me down by putting in June on these things, and I'm scratching it out and writing it in, and the prosecutor is talking fast, and she's not, but it's not on you.
I'll slow down.
The lawyers really do need to put the right month on here. So I'm just trying to go through here and make sure. I think I missed a few.
Okay, I can go back.
Oh, no, I just asked the clerk to change it for me.
We'll change it.
The clerk is authorized to change it from June to July. I tried to keep up. Go ahead, you can continue.
Johnny Ray Williams, 2023 CF 741480. The state has filed a notice of no information.
I'll grant that motion. You can go faster. I've gone through and written July now.
Okay.
On all the rest of them. It's just that almost every single one had the wrong month, almost every single one. But I'm good now, so go ahead.
On Jordan Mikesha Corinon Smith, 2023 CF 735980. The state has not filed on that case.
I'll grant that motion.
On Samadre Antoine Dunstan, 2023 CF 7305A. The state has not filed on that case.
That motion's granted.
On Adam Christopher Bird, 2023 CF 749580. The state has not filed on that case.
I'll grant that motion.
On 2023, Inderjit Singh, 2023 CF 741980. The state has not filed on that case.
That motion's granted.
These are add-ons. James Edward Booker, 2023 CF 7119. The state has not filed on that case.
That motion's granted.
Shayna Adele Kaplian, 2023 CF 737080. The state has not filed on that case.
I'll be granting that motion as to Capellan.
Daniel Negrin, 2023 CF 720480. The state has not filed on that case.
That motion is granted as to Negrin.
Kristen Jane Shaw, 2023 CF 745280. The state has not filed on that.
I'll be granting the motion as to Kristen Shaw. I want to go back to Brett Michael Dye, DYE, 2023 CF 7578AO. And what's the state's position on the Dye motion? I fell behind, sorry.
On Michael Dye, the state has not filed on that case.
That motion is granted.
Your Honor, could we go back and address the case? It was the last case, Rodriguez Michael, for a VOP. It was
Yes,
a
ma'am.
review. Based on my review, it does not appear that he was still on probation.
May I see that file?
I was reading something about,
When I looked, it showed that he pled to. They did an on view, but it shows that he pled to that and was sentenced. It says revoking.
Can we, the clerk needs to hand me the file back, so I need you to give them the clerk the name again.
Rodriguez Michael Cintron. He was the very last one. It was a felony warrant VOP. It was the last case we did.
I think it's CF 21-14555.
All right, readdressing Michael Cintron Rodriguez. Defense, you believe he had already completed his probation? And why do you believe that?
It says I'm looking at the admission to violation of probation, saying that the prosecutor has agreed to admit that he admitted to the VOP, revoke and terminate probation, sentenced him to 10 months in the Orange County Jail with credit for 267 days.
When was this done?
February 20th, 2023.
And when was the on view was?
It says that on 3/15, he committed the new law violation.
Well, if he was out, then that means he served the time. If he was sentenced in February, if he was out to commit a new law. Was it 2023 or 2022 when he was sentenced?
He was sentenced February 20th, 2023. He admitted the violation of probation.
And the new law was March 2023?
Yes, and I'm just gonna.
Then he would have had to have finished his sentence to be out.
Yes, Your Honor, because he was supposed to do 10 months Orange County Jail with treatment in the Orange County Jail, credit for 267 days. So at that point, by June, he probably was finished. I'm just trying to see the new case.
I'll readdress it at 1:30. I'll also readdress Kamari Lucas at 1:30.
Okay.
Court's in recess until 1:30.
Thank you.